kuingia ndani ya mazungumzo haya kwa kina, nataka turudi mahakamani ambapo kesi inayofungamana na kubanduliwa kwake mamlakani aliyekuwa naibu rais Rigathi Gachagua inaendelea katika mahakama ya Milimani kwa sasa hivi, ambapo upande wa utetezi uko pale kuweza kujieleza kuhusiana na yale majibu ambayo yalipeanwa na upande wa utetezi ambao ni upande wa bunge la kitaifa na seneti, na vile vile naibu rais Kithure Kindiki ni miongoni mwa wale waliokuwa wamewasilisha utetezi wao, na vile vile mshtaki ambaye ni Gachagua pia atakuwa anapeana baadhi ya zile majibu ambayo yalikuwa yamepeanwa na upande wa utetezi. Hebu tusikize upande huo wa ulalamishi.
By enacting Public Order Amendment Bill of 2025 that seeks to control how Article 37 is exercised in this country. And so Parliament is saying that we have the power even to govern the people themselves in the manner that they would exercise the powers of directly. But when it comes to us as Parliament, do not touch. And that is why there were submissions related to the question of judicial review, whether it's going to dig into the merits of this case. I find it interesting that when it comes to members of county assembly, the County Government Act, Section 27, says that you can recall a county member of parliament, a member of county assembly, only upon a judgment or finding by the High Court. If these accountability measures that have been provided by the Constitution seeks to limit the power of the court, why is it that then when it comes to county members of assembly members, a court has to participate, but when it comes to impeachment, the court is limited in one way or the other? That's the context that these impeachment proceedings are before you, and it is very important to see the power play that Parliament is actually engaging in. Parliament is claiming immunity, and that immunity, from my view, is trying to put this court under limitations on the question of judicial review. My lady, my lord, Article 10, looked at from the set theory, has certain elements of values. And one of those elements is that of accountability. And there is nowhere that accountability is classified as to whether it's political accountability, economic accountability, or social accountability. It is simply accountability. Such that when you talk of accountability, then it is within its breadth and width. It is not limited in any way. And therefore, all the submissions related to that question, this court must be allowed to exercise judicial review in its entirety. And judicial review in this case must include rationality review. Were those decisions rational? Review of evidence. I listened to submissions from one of the councils the other day, and we were told that 281 members of parliament voted for this motion. What I find interesting in that submission is that you are given the impression of how overwhelming the support was for the motion. But there's something that you're not being told. That never before has Parliament has such numbers when it comes to performing their primary function, which is legislation. My lady, my lord, I find it interesting that 5 times the public participation bill has failed. The first attempt was in 2016. I invite you to just consider those bills. 2016, second attempt in 2018, that attempt in 2019, fourth attempt in 2023. It never passed. The recent one is in 2025. It is very interesting when you look at all those bills and you see the departure pre-impeachment and post-impeachment. The 2025 Public Participation Bill, interesting enough, seeks to say that once public participation is conducted by Parliament, then the Senate may just adopt whatever has happened in the National Assembly, which was not the position in the previous bills. And so, my lady, my lords, we have a Parliament that is seeking to benefit from things that it has failed to do. If you go to Schedule 5 of the Constitution, you will realize that the timelines were very clear. Public Participation Bill was supposed to have been passed within 3 years. The right of recall was supposed to have been passed within 2 years. None of those things have happened. And at one instance, you find Parliament is able to mobilize 281 members to just vote for impeachment. In other words, when it comes to accountability of presidency, the numbers are available. When it comes to passing and performing the legislative functions, numbers are not available. There is an indictment on Parliament, even in the impeachment proceeding itself. Out of 11 grounds that were submitted to the Senate, 6 of them failed. In other words, 281 members of Parliament passed 11 grounds that could not meet the threshold when it came to the Senate. 281 members of the National Assembly. Is the attempt to curtail the powers of this court on judicial review, fear that the remaining 5 grounds will totally fail. Maybe that's what is driving this question of power. I want to conclude by mentioning a statement that was made by Isaac Newton back in the 17th, 18th century or thereabout. An accomplished scientist. Isaac Newton lost half of his fortune after investing in a pyramid scheme, what we would call in modern day language pyramid scheme. And this is what he said, that I have calculated the motions of heavenly bodies, but I have not been able to calculate the madness of people. The drafters of this constitution calculated everything that they could, where to place the word shall and where to place the word may. They calculated which institution would have which powers. But I submit before this court that it seems that they had not anticipated the madness of people who are seeking to overthrow the constitutional order and take this country, the Westminster Parliamentary kind of democracy. We are a constitutional democracy. And any attempt to take us in that direction, where Parliament becomes the most powerful institution in this country, as compared to the Constitution, that attempt must fail. In making your decision.
Bila shaka ni kesi ile inayofungamana na kubanduliwa kwa